Okay. Hello and welcome everyone. We're going to start the webinar now. I think everybody had time to join. Thank you for joining us today. Benjamin Mendez introducing today's webinar. The webinar, which is hosted by Questel. We're a provider in IP tools and services. So if you have any questions, feel free to ask. And one quick tip for today, you can see on the top right of your screen, there's a little box with a question mark, and it says Q&A under it. If you want to ask questions to the panelists, please go ahead and do it through that section, and we'll respond to the questions at the end of a session during a little Q&A session. I'm going to introduce Michael LoCascio, who's our speaker today. Michael is an IM300 IP strategist, currently responsible for global IP strategy for BASF Catalysis division. He has implemented IP management processes to improve invention capture, optimize patent portfolios, monitor competition, and detect potential infringements. Michael also led the effort to develop the market entry and M&A strategy to help BASF expand into the medical device sector. So Michael, if you're ready to start, it's you.
Thanks so much, Ben. And I'd like to also thank Questel for giving me this opportunity to speak to the audience. I do have one disclaimer. I had a brief conversation with my attorneys who insisted that I said any opinion that I'm about to say or anything that I should possibly suggest has absolutely nothing to do with BASF at all. So anything that I may say is unconnected to BASF and is my opinion and my opinion only. Anyway. So moving on to the presentation. So today we're talking about what I would consider the 6 strategic competitive force. So Michael Porter famously described 5 competitive forces, and I would like to suggest that intellectual property innovation may be part of one of the forces, but I would suggest it's actually a separate force that companies can use, but oftentimes do not use appropriately in order to achieve their business goals. And in order to achieve those business goals, it's really several things, and this is what the crux of this discussion will be about today. So I'd actually have to implement the appropriate IP management processes to develop how to develop strategies and how to execute the strategies, again, to leverage your IP assets to achieve your business goals. So the first question is, what are the actual elements of a comprehensive IP strategy? What is your strategy supposed to achieve? Now, clearly, I can't describe what BASF's IP strategies are, but I can say that it involves a variety of different things that have to be considered. So all the best practices in IP strategy require really multiple dimensions. Obviously, the most obvious, is the internal elements, in particular creation and capture of IP. So these are the various strategies to employ to basically determine whether or not you have intellectual property and whether or not to encode it as a patent or have it in utilizing some other method. Managing and monitoring, of course, is incredibly important. You have to not only obtain your intellectual property, but you have to make sure that you are utilizing it correctly, that your portfolio is the appropriate size and cost, and that it's actively winnowed out such that you're not absorbing excess costs on assets that have very little use. Most importantly, and most times which is overlooked, is the coordination function. And I'm going to go into some depth in this in later slides. But IP does not exist in a vacuum. And it is part of an overarching strategy. It's an asset that is utilized in an overarching strategy that's used to achieve the business's goals, okay? And that's something to critically understand. And as such, coordination of the IP strategy is intricately linked with every other aspect of the business, and we'll go into that in some further detail later. On the external side, there's a series of other elements, of course. So even though you're developing your portfolio and managing your portfolio internally and trying to understand what the competitors are doing and having that reflect in your own portfolio. Again, intellectual property is an asset, and as such, you should do something with it other than just collect it in a big pile or maybe make some posters on a wall. First and foremost is transaction. This is very simple. This is in-licensing or out-licensing generally. but it also encompasses defending and asserting your IP. So once you have your assets, most definitely you will, if you're not transacting, you may be engaging in an assertion effort to prevent others from utilizing your intellectual property. Or conversely, you may be defending not only your own products from external IP, but defending your portfolio itself. I think many people on this phone are aware of the many types of oppositional techniques that are used to put holes in your own portfolio. And very oftentimes, it's an element of the strategy to defend your IP portfolio, which in turn defends your technology position in which you've invested so much in. And lastly, on the external side, and something that's almost always overlooked, is influence. And that really takes on several aspects. On one hand, it may be very important to communicate your IP position and, in some degree, your intent to your suppliers, to your competitors, and most certainly to your customers, so that everyone is aware of what you have and there's no misunderstanding there. It also may be, this is sort of dependent upon the company, of course, on, all intellectual property rests within a framework of rules set by the government, legislative rules, as well as a web of judicial rulings. And the influence strategy can extend beyond simply operating within those rules, but actively attempting to try to have those rules altered, obviously in a legal manner. But I think lobbying is something that's oftentimes overlooked, and particularly for larger companies that are spending many millions or hundreds of millions of dollars in resources that it should not be overlooked and utilized to its fullest extent. And of course, utilizing these various elements is for three basic things, right? So the first and foremost is we're going to try to implement and create a strategy using these elements that secures the future, that basically allows the company to be able to practice its technologies, its products, without encumbrance, and be able to practice the best mode. And so you just don't want to be stuck being in the market with a product that's substandard relative to your competitors. Of course, this is an asset that has been developed over via R&D. So companies are expending, not just companies, universities and other institutions as well, are expending substantial resources in developing technology and know-how. It is important to be able to utilize IP to protect what you have invested in. And lastly, of course, you can use IP to create a profit stream. Also, in some cases, to reduce costs if your patents are becoming too costly or oppositions are becoming too costly. But this is something that's incredibly important. It oftentimes makes a lot of sense to extend licenses not only for markets and applications in which you're not planning on practicing, but oftentimes it does make sense to strategically engage in licensing even to your competitors, and that sort of depends on a lot of different factors, including the potential to expand the overarching market, for example. And again, I can't go into detail about what BASF does, but we definitely look at all three of these outcomes to the strategy itself. So moving on, so we know now what the elements are, but how do you actually do it? How do you actually start engaging and developing a strategy that incorporates those elements? And specifically, what internal stakeholders are needed to be harnessed in order to achieve your overarching goal? So this is what I would consider the traditional view, and this is a very simplistic view of IP, and it's one that really doesn't work very well at all. Most companies, I wouldn't say most companies, many companies are obviously moving away from this, but I speak on a number of panels, I speak with lots and lots of companies, and I'm oftentimes very surprised at the lack of sophistication and the lack of attention that's paid to intellectual property in general. The traditional view, of course, is that IP is a very sort of linear action between R&D and IP counsel. Research and development groups invent something, they notify the patent attorneys, and the patent attorneys write a patent, and that's about it. That's the extent of it, which of course leads to a lot of different problems. If you don't have your processes in place, you're only engaging R&D and IP counsel, very oftentimes you end up with very poor internal IP capture because you rely upon inventors to self-identify a patentable invention, and oftentimes they aren't aware of what is potentially patentable. Decision-making is oftentimes very slow and painful, and you might end up with invention record backlogs that never get patented. You may end up in situations where, because the decision-making is so slow, the researchers are both actually write the appropriate invention records in the first place. Because R&D and IP counsel often don't speak exactly the same language, you may end up with weak patents and portfolios certainly with holes. You may not understand what the competitors are doing. You may end up with poor contractual language that confounds some of your efforts to utilize IP. You may be filing in the wrong countries, which is oftentimes the case, where you see patents being filed in all sorts of countries that have, basically no bearing on where the competitors are, where your markets are, or anything of that nature. So what happens? I mean, the result of doing all of this poorly is, of course, elevated costs. You have risk associated with trade secret theft, which could be very, very damaging to your companies. You may have competitors that are infringing on your IP, and you're not either aware of it or don't have the capacity to do something about it, or the opposite. Perhaps because you're not doing things well, you're infringing on others, and you have those associated risks. And you may also threaten your ability to enter new markets, or certainly practice the best modes. This is a lot of problems, again, occur because people do not have the appropriate people, the appropriate structures involved in intellectual property. This is how I think of intellectual property. That actually sits at the intersection of three major segments: technology, not just R&D, law, and business, okay? So the technology front, it's not just your R&D department, but it's also your engineering, which may be separate from your R&D, and oftentimes production, which have their own level of technologies, and most certainly trade secrets, which need to be protected. On the legal side, of course, you're dealing with your IP counsel on a daily basis, but you also have to engage, the IP strategy itself engages with contractual law, oftentimes litigation counsel, unfortunately. And again, if you're utilizing an aggressive influencing strategy, certainly your government affairs officers. On the business side, and this is the most crucial, obviously marketing, sales, finance, and even purchasing. And again, people think wrongly that intellectual property is simply a sort of legal device, oftentimes run by patent counsel. In fact, if you think about it, even the most basic decision around a patent has nothing to do with legal, right? Whether or not to file a patent is not a legal decision. Where to file a patent is not a legal decision. The decisions on whether or not to utilize a patent, to license it, and at what value you plan on licensing it, or whether or not to assert a patent, obviously involve legal, but it is not ultimately a legal decision. Business plays a critical role in IP strategy. Okay, so moving on. So now we know what we know what the elements are of an IP strategy. We know what a poor interaction looks like, only R&D and IP, and we know what we'd like to get to, which is an appropriate interaction between the business, technology, and legal in order to obtain your appropriate IP strategy. So how do you get, if you're a company, most companies fall in the former category where they're not executing appropriately and they're not utilizing their IP. How do you get from that point to a point where you have a highly functional IP strategy and are leveraging it appropriately? So I look at this actually as in three fundamental steps, and these steps can take quite a long period of time, okay? So it takes three steps that are sequential, not completely in series, but not in parallel either. First and foremost, and in my opinion, the most important, is the implementation of IP management processes. Well-oiled machines are required, and followed by the development of actionable strategies. And I don't say a strategy oftentimes. You may have overarching strategic principles for a division or a company. But really an IP strategy is multiple, relatively narrow strategies that have achievable targets and goals. And then, of course, there's the execution of that strategy. Now, I've had a lot of discussions around this internally and with a lot of other people, and there tends to be this thought that this is in many ways inverted, at least the strategy and process part is inverted, where you first have a strategy, then you implement processes, and then you execute. I would suggest that's completely and utterly wrong. And my analogy is that it's like you could have a great general and you're ready to go to war, but if you don't have a trained army that's unequipped and doesn't know what they're doing, it doesn't matter how skilled the general is or how great the strategy he's proposing, it will not get executed. First thing to do with an army is to train it appropriately. Then you develop a strategy on how to utilize what you have at your disposal, and then move on from there. So in the next few slides, I'm going to go into a little bit more detail on each one of these elements, process implementation, developing strategies, and of course execution, followed by a couple of tools of the trade that help you progress in these areas. So the first step to develop a strategy is really to understand what the companies are presently doing. Most firms do something. They may have some IP committees in place that sort of function, maybe they don't quite function, who knows. But the first step is to understand what is presently being done. And I highly advocate primary interviews. This is from my old days as a consultant, where it's really important to get in the weeds, talk to as many people as possible, talk to the researchers, the business people, everyone you can imagine that could be potentially touching IP, and ask them a series of questions about what they're presently doing, if they're involved with it at all, how, if costs are a concern, how the licenses, if they exist, are being managed. Talk to leadership and the business managers, just basically get an understanding of what's going on. And once you have that, once you have the understanding of the current processes, then you can start evaluating what's missing, all right? So, and there's usually quite a bit of holes that you could say are not being done appropriately. And then I highly advocate trying to take the existing infrastructure that's in place and morphing it to become better. I often find that it's very disruptive to walk into an organization day one and say, this is how we're going to do things. This is the right way to do things, and this is how we're going to do it. And all the preceding activities that you've been engaged in are completely wrong, and we're just going to throw it away. That creates a lot of animosity, creates a lot of resistance and blowback that really inhibits the development of the appropriate IP management process. So I highly advocate against that. Understand what you already can do, understand what you're not doing, and leverage what you have to get from point A to point B. That's the first step. So what are the potential holes that you may have? Ultimately, what processes do you actually want to put in place to make a highly functional team? And again, I cannot reiterate anymore that without your processes, your IP management processes in place, your strategy is just that. It's a bunch of pretty slides that you've presented to leadership and you can't execute. That's completely useless. IP management is absolutely critical. So what does that mean? So, at the most basic level, you really have to have an understanding of what your IP portfolio comprises. Now, some people may just have a simple list of their IP. That's really insufficient. You really have to have a detailed knowledge of what you own. And I highly advocate generating a very detailed spreadsheet that has all the relevant information around the patents and the associated families, what products they are related to, when they're expiring, and things of that nature. Another basic one is around marking and virtual marking. I highly advocate this. In the absence of marking, it's very sometimes challenging, or you end up losing potential damages. And there's ways of doing this even on chemicals that allow you to mark, which is very important. Trade secret protection, of course, is incredibly important as well. It turns out that, in fact, the majority of the intellectual property you own is not encoded in patents at all. But maybe equipment, maybe specific processes, maybe, who knows. All sorts of different information that's scattered around the company. In order to adequately protect your trade secrets, you have to, first of all, train your employees. You have to know what your trade secrets are, and then you have to take adequate steps to protect them. Otherwise, at least in the U.S., they're not trade secrets. Beyond that, this is where some of the tools start coming in, becoming very important. Information gathering around competitive IP, so monitoring what the competitors are doing, being able to sample and test products effectively, being able to proactively capture your internal IP, and also processes around making decisions on your invention records, quickly getting them through the process, and being able to have a quality control on your IP, so to speak, where you can review it with a series of people to make sure that the claims themselves are sufficiently strong and broad. Analytics around where you should be filing patents, understanding, again, how your patents and IP relate to your products, and being able to then translate that into costs. How much will your portfolio cost, and also how much cash flow does it protect? And then, of course, then you have to have your decision-making capacity in and of itself, which I'll discuss now. IP committees. I can't stress enough how important IP committees are. They are the central forum for making at least tactical decisions around your portfolio and how to use it and how to grow it and how to strengthen it. It has to, just like I mentioned earlier, it has to incorporate all the elements that are involved. It has to involve the business, it has to involve R&D and technology, and it has to involve legal. And this group of people, and by the way, it may not be one. I mean, you may have many IP committees because some of the technologies and products and perhaps regions in which you're operating are so vastly different that different expertise is needed. It's not an IP committee. It's potentially many IP committees that comprise the people that I mentioned, the stakeholders, and that meet regularly. And their job is to make decisions on the portfolio, whether or not to go forward with an invention, what jurisdictions to file, how to strengthen the IP if necessary, and really do the groundwork on looking at the competitive IP and what to do with it, what to do with it, if anything, and how to capitalize on opportunities. So they're also intimately involved with whether or not to license, whether it makes sense or not, or whether or not it will injure the business in some way or help it. So this is critical to get functioning. It's sometimes challenging to do that, to get it well functioning, but this is an absolute must. All right, so once you have your IP processes in place, and once you have your IP committees and your decision-making mechanisms in place, the next step, of course, is to develop the strategy. So you're developing your portfolio, you know what you're doing, everything's running smoothly. Now, the strategy is, what are you going to do with your IP assets? How are you going to leverage them to meet the needs of the business itself? And this occurs in 3 distinct steps. The first one is an assessment, okay? This is just like you're assessing what your current processes are in the company, you're assessing the IP ecosystem and landscape for your strategy. So the first thing you have to understand is, of course, what the intellectual property is and in the area in which you're targeting. What are the associated trends? Is it increasing, decreasing, et cetera, country analysis and things of that nature. But what's also very important is to understand the business landscape, what the business needs, what they would like to achieve with their intellectual property, whether that's maintaining market position. If they're exiting the market, perhaps the IP strategy will be focused around licensing. Who knows? But that's critically important as well as understanding what potential customers are, the technology landscapes, and how new and emerging technologies are upcoming and how that will affect not only the business but the IP portfolio, your portfolio, and the landscape in general. The analysis has to include, of course, your competitor analysis, which is more than IP. This also involves their financial and their technology and their product capabilities. And econometric analysis are, of course, important. And it's something you have to do if you're engaging in a potential licensing arrangement or an assertion strategy or what have you. Everything boils down to a financial calculation and whether or not it makes sense to move in a certain direction. Oftentimes, I find that Bayesian-type logical analyses are very valuable, where you conduct a multi-scenario financial calculation with different assumptions, and you're basically suggesting that a specific path will be followed, but you have other backup plans in case your starting assumptions start changing over time, and you could revert and change strategies on the fly. And of course, those two things lead to your strategic approach, and this is sort of an iterative process where based on your assessment and your analysis, you could start selecting from various strategic approaches, including, but not limited to, enforcing strategy, insertion strategy, licensing strategies, filing strategies, which could basically be how you plan on building your portfolio, and if there are specific white spaces which are important, which you should try to capture, as well as your regional strategy on which countries it makes most sense to file, which it may make sense to oppose, and things of that nature. So these three steps to develop your strategy, again, once you have your processes in working order. So now I'm going to move on to some of the tools that are very useful in not only developing your strategies and executing your processes. Sorry, not to working through your processes and developing strategies and executing upon them. And there's a number that are used. I think first and foremost is your IP management system. There are quite a number of IP management systems out there. The simplest are forms of spreadsheets or, I don't know, databases and things of that nature. It's incredibly valuable to have this in place. The issue, unfortunately, is that most of these systems are focused on and dedicated to sort of legal and tracking specific legal actions that have to take place. And they don't fully allow an IP strategist or the IP managers to fully understand what they own, the relationship between what they own and licensing, for example. Some do, some don't. Reporting is oftentimes weak. There are some companies, including Questel now, that has a very interesting offering, which is trying to correct for some of the flaws of a lot of the competing products, and it's becoming very exciting. My little shout out to Questel, thank you. The second, and the one that I utilize most as an IP strategist, is of course your IP analytics tool. This is absolutely critical. Obviously, Questel makes one, their Orbit system, which works fantastic. There's a few others that are out there as well. And again, your intellectual property is a very valuable asset, and it's really critical to understand what you own and what the competitors are doing out there. And so the tools are required to be able to quickly search through other portfolios, be able to understand what they contain, the various trends that those portfolios are undergoing, both over time, but also understanding of clusters of technologies and semantic clustering, but also clustering of continuations, which sort of shows that the competitors are valuing specific patents very highly for some reason or another. So this is a critical tool that's utilized for developing landscapes to help understand what the white spaces are in not only your portfolio, but in the overarching landscape, how patents are interrelated with one another, and really is required to help you develop the follow-on strategy. All right. Oh, and there's a little note here that something that's very important too, particularly in the past, IP management systems were isolated, and your IP analytical tool was isolated. And because they were isolated, you actually it was very challenging to perform a high-fidelity analytics, a high-fidelity analysis on your own portfolio itself, which is sort of strange. It was, in some ways, easier to do it on competitor IP than your own. So I think that, I know that, in the case of Orbit, they are connecting those two together, which I think is going to be very interesting going forward and be very important. And I think that would be really a critical development in the area of IP analytics and strategy overall. And lastly, this is something that I really think is incredibly important. So, you know, companies are huge. there's a large number of stakeholders that we described before, a large number of processes, right? How do you get the complex information associated with intellectual property, the appropriate people, at the appropriate time, the right format, and allow them to make the right decisions quickly and seamlessly? So there are some potential solutions out there, and okay, one of the problems in companies generally is that the people that oftentimes know of a particular issue are disconnected from the decision-making process, sort of like the phone lines are cut, okay? So you could, so for example, you might have people, your applications engineers or your sales force, for example, they may have stumbled across a competing product that they believe is a little close or maybe potentially infringing on something that you have to offer already. In most organizations, those people don't know where to go. What do they do, right? There's really nothing. They might, grouse about it internally, but no action is ever taken. So the key is to develop your processes in such a way that those people who determine that there's certain information of interest out there are appropriately connected to the bodies, the decision-making bodies, in order to make a decision on what to do about it. So how do you get the people that know that information to the IP committees ultimately? And how do you do it in such a way that it's simple to use? So there's not a lot of, people don't like learning new tools. They don't like things that are too challenging to use. So how do you do that in such a way that if they know something, they can very easily provide that information to the people that the appropriate go to make a decision, okay? And how do you do it in such a way that there's appropriate level of governance? Well, there is actually a way of doing it, and it's leveraging your whole company as sort of like a distributed computer or sensor, where they collect information, perhaps it's information not only on competitive product, but on competitive intellectual property. It's delivered, and it's delivered in such a way that they could simply read it, click it on it if it warrants for the discussion, and it gets routed to the appropriate decision-making groups that could then reevaluate and make a decision. So this is something that is incredibly important. And this is sort of an example of how that would work. Your researchers would receive content. They would then review it. It could go potentially to group leader for further review, and then on to IP committees for further decision. So this is an example of how to leverage your entire company, again, not just your R&D and your IP council, but the entirety of your R&D, as well as your business community and others, funneling that information to the people to make a decision on whether to act upon IP, the competitive IP or not, in this instance. But you can imagine that there's other ways that you could utilize your company as a whole to perform other functions with R&D, with IP as well, which I think would be subject for another webinar as we're starting to run a little bit late here. So at the end, again, in finality, once you have your IP processes in place, you can develop and then execute upon your strategies that have the elements that I described earlier. And with that, I think we are at our half-hour mark. And if there's any questions, I'd be happy to answer them.
All right. Thank you very much, Michael, for the presentation. So there are several questions that people wanted to ask you. One of them, you've mentioned trade secrets a few times during the presentation. So why do you think many in-house IP managers feel that trade secrets fall outside the area of responsibility?
Yeah, I think, so first of all, I think that there is a substantial difference between an IP strategist and an IP manager. But anyway, I think IP managers tend to focus on patents because they have associated, because they're more solid, okay? They exist in a easy-to-utilize form. They have certain costs associated with them. They're very tangible, or much more tangible than a trade secret, okay? To understand what a trade secret is involves a lot of effort. It involves a lot of training for people to actually identify what a trade secret is, often engaging with legal. And then you have to not only train people, but actually catalog and have an understanding of what they are. This is extremely time-consuming and, frankly, is a little bit, in some cases, ephemeral. And then, of course, you have to take the appropriate actions to protect them. So I just think that they find it outside of their comfort zone, even though it's critically important. In fact, it may be more important in some respects than the patents themselves, okay? A lot of times you have tricks of the trade in your manufacturing processes, without which, you would have substandard product. It's critical. And if that information were to leak out, which it very well may, right? You have employees from around the world coming and going into and out of your organization. You have customers coming in and out. You have suppliers coming in and out. You have equipment manufacturers. I mean, it can leak. It does leak, and it could be incredibly damaging. So it's very important to get that under control. And I just feel as though it's out of the comfort zone of most IP managers, and they just simply don't do it. And by the way, I know I'm probably drawing on a little too long. Again, it is not simply just the IP manager. The IP manager may have to organize certain activities, but it most certainly incorporates other parts of the organization. So, for example, operations would have to be engaged, including manufacturing oftentimes. Perhaps application engineers or process engineers have to be engaged. By the way, your IP extends even into your sales organization. Certainly your trade secrets and things of that nature, certainly lists of your customers, lists of your suppliers, your bill of materials. All of these things are critical information that you don't want to escape. So it involves a lot of people, not just the IP manager. I don't know if that helps with the answer. It's a big effort.
Thank you. Another question. How did you convince legal, or was there some convincing to legal that you had to do to allow engineers to review and annotate competitors' patents?
Well, yes, actually. And I think part of it's the annotation. So, discovery is a very interesting thing. And this is very serious and has to be taken into consideration. And I know of many organizations that actually take the stance where they don't wish anyone in the organization to review competitive IP for fear of willful infringement. I think, which, by the way, if you think about it sort of from a philosophical standpoint, is 100% antagonistic or antithetical to the whole purpose of intellectual property, which is the government is extending a time-limited monopoly in exchange for public disclosure of the information. So the very fact that people are actively refusing to review the information, I find troubling. I think it's a troublesome development resulting from, frankly, from IP law. With that said, our company and many other companies want to make sure that we have a good understanding of competitive IP specifically in order to not infringe. Many companies simply don't look at intellectual property. Many others make a point to do so. And as far as annotation is concerned, that is something that has to be very carefully controlled. And you do not want people making opinions, frankly, that may or may not be true. Ultimately, the opinion comes from legal counsel, okay? They may denote something that may be interesting. By the way, it may not only be interesting from an infringement standpoint, it may be interesting from a licensing standpoint, right? Maybe infringing for something in the future. So it's not just straightforward, infringement or not infringement. There are many reasons why you want your engineers to review IP, but you do have to be careful on what is said and how it's said, and that oftentimes involves a lot of training. Don't forget, engineers, they may think something that ultimately is not true, and it should not be on the record that that's the opinion, because oftentimes they're not right. They're not the experts in the law. They don't know if something is or is not valid, and that's really a legal question. So tight training, and other ways of sort of reducing the ability for people to simply opine on their own.
Okay, interesting. One more question. You talked about IP strategy. How long did it take you to implement this at your company?
Well, I think I'll get too much detail about how long it took at BASF, but it takes a while, okay? And frankly, it's a never-ending process. It's like the 80-20 rule. Most of the egregious problems could be solved fairly readily within a period of months, and others, take a long time. So to get from a complete failure to, a B+ could take a few months, but to get from a B+ to, an A could take years. And, and again, I think everyone is familiar. I know a lot of people on the phone are from major organizations. It also takes, just because you have a process that's put in place, if you take your eye off that ball, that process very well may fall apart. So implementing processes takes time, but also it takes a lot of effort to make sure they're appropriately maintained. It takes quite a while. On the strategy side, an individual strategy, it sort of depends. I think the overarching goals don't take too much time, but then a targeted strategy, each individual one may take several months of hardcore investigation and reading through patents and really getting a clear understanding of your own portfolio and others' portfolios, as well as getting alignment with all the other alignment and coordination with the other groups that are involved. So, you could say one thing, but if that's against what the business itself is looking to achieve, well, guess what? Your strategy is not right. So it takes quite a bit of time to develop individual strategies. And of course, on the execution side, it could take months to years depending on what you're doing, right? So. Okay.
One more question, Michael. What are some best practices for identifying potential licensees and or assignees for IP?
And assignees, so potential licensees, so those that you wish to license to. Well, I think there's a lot of potential routes, and it sort of depends upon your strategy. So if you have a strategy of strategic licensing, which I define as extending licenses to those that are somewhere in your value chain, so it could be your competitors, your suppliers, your customers, or something like that, that's pretty easy to identify. Most companies know, most firms know who their competitors are, who their suppliers are, and who their customers are. It's a little bit more challenging if you have an opportunistic or adjacent license. So in which case, I would identify those as utilizing your patents or your technology either in an area in which your company is not interested in or a potential application outside of what the company is interested in. So maybe you have one technology that's used for dual purposes. The company is commercializing one but not interested in the other. That could take a bit of time. And again, you have to do a market study and try to get an understanding of who the players are, both large and small, and start engaging them. And just like I said early on, when you have to go internally with primary interviews and talk to people to get an understanding of what's going on inside your company, I advocate that for outside the company as well. So speaking with companies, engaging in conferences, engaging in webinars and things of that nature, it really helps build relationships with other firms that may ultimately may have interest in intellectual property of your own. So I would take those two routes. And the third, of course, is inbound, which is if you've established yourself and established a reputation and communicated to the overarching market that you may be interested in extending licenses or what have you, oftentimes they approach you, which makes life very easy.
All right. Well, Thank you very much, Michael, for your presentation. Thank you, everybody, for attending the webinar. If you have some more questions or if some of your questions have not been answered yet, don't worry about it. We're going to gather all the questions together and come back to you, as well as sending the recording and the presentation of the webinar. For people that are interested in this topic and want to see more in details how it looks like, you're welcome to join Catalysis webinar next week on the same topic. So there'll be a basic session on the 28th of September and an advanced session on the 29th of September, how to implement the workflow that Michael mentioned during the presentation. So again, thank you everybody for attending. Thank you specifically to Michael for the presentation, and enjoy your day.
Thank you. Take care.